Hi, I'm Tom Marks with the Marks Law Firm, and welcome back to the Healthy Family Law Attorney video series on YouTube. Thank you for joining us. We are finishing up our 4-part series on what to do in a custody battle. What are the factors under the Florida statutes, section 61.13? And there are 20 factors. So in the first 3 videos, we've gone over the first 15 factors. And now we're going to dive into the last 5 factors in this part 4 of the video series. If you didn't watch the first 3, go back and watch those because it's going to be very helpful to you. So your family matters, and so it is our purpose to provide hope and help to your family in the family law process, whether it's divorce, custody, paternity, or whatever you're going through. We're here to help you. So we want to do it in a healthy way. So I will be giving you a healthy living tip at the end of the video, as I have on the prior videos. So let's dive in. Factor number 16 under the Florida statutes, the court must look at in every family law custody case, which is going to be involved with the parenting plan, whether there's going to be sole or parental, shared parental responsibility. Factor number 16, the demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Okay, so this is similar to factors number 2 and number 15. Factor 2 was the anticipated division of parental responsibilities. And factor number 15 was parenting tasks customarily performed. So those are similar, but this is drilling down into exactly what the parents are going to do with regard to school and extracurriculars. So think about it in these terms. The court's going to want to know that you're very involved with the kid's school. You're going to want to know the names of the teachers, the classes your children are taking, what their how they've done on the tests so far during the year, what their grades are, prior year teachers, teacher parent conferences that you've been to, those kinds of things for school, so that the court knows that you're a very involved parent. This is an important factor for that. Also, extracurricular activities. So are the kids in extracurricular activities? You'll need to know what they are, if they're sports, who their coaches are, if they're dance, who their teachers are, and so forth. So before you ever get into the courtroom or even a deposition, you need to know these factors and you need to know this information. Your attorney should adequately prepare you so you're not caught off guard, so that opposing counsel or the other parent can't make you look bad to the court with regard to these factors. So let's move on to number 17, the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. All right, so we've already talked about moral fitness. So this one is about substance abuse. So it can be alcohol, it can be illegal drugs, or even abuse of prescription drugs. I've seen that many times in court proceedings where one spouse will accuse the other of abusing prescription drugs, obtaining painkillers from the doctor when they're not needed. But more often than not, I see where one parent will accuse the other parent of excessive alcohol consumption, excessive partying, driving the children in the car under the influence. So there's a powerful device called SoberLink that we utilize oftentimes, where one of the parents will have to blow into the device, be tested for alcohol, blood alcohol levels before, after driving the children, hopefully before you let them drive the children, or even during the timesharing period. So it really depends. This can be done by agreement between the parties or their counsel, or it can be ordered by the court. So the SoberLink is one option. There are other options like random drug testing, different types, hair follicle, nails, whatever, that will show that there's been drug use within a set period of time. I've seen people actually cut their hair super short to try to avoid that, or cut their nails super short. Those are obviously telltale signs when that's not common for them. Okay, moving on. Factor number 18 of 20 under this statute: the capacity and disposition of each parent to protect the child from the ongoing litigation, as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. Okay, this is a super common problem in family law cases where the parents involve the minor children in the litigation. They'll share court orders, they'll share filings, what they may have filed in a motion with the allegations about the other parent. They will sometimes use the children as vessels for communication with the other parent. They'll show the children different documents in the case. All of this is terrible. It involves children in adult issues and litigation issues, which the court will punish the violating parent for. This is one of the harsher things I've seen judges penalize parents for. So don't talk to your children about the case. Don't tell them where you are in the case, whether you have a hearing coming up on a certain motion for contempt against the other parent, or even when the trial is. Those are not issues for the children to be involved in. And the non-disparaging part of it is really important too. Oftentimes, if there's a lot of trashing the other parent, disparaging the other parent, and kind of trying to get the child on your side, what the lawyers will often do is ask the court for an order for a social investigation, for a parenting coordinator, for a guardian ad litem. I like the social investigation because it's typically performed by a skilled psychologist with a PhD. It can be a licensed mental health therapist, but they can often get from the children what the parents are saying. And they may do play therapy, tray therapy with the children, younger children, to find out whether one of the parents is trying to alienate the children from the other parent by disparaging the other parent. And then that social investigator or that parent coordinator or even a court-appointed co-parenting therapist, they can make a report and recommendation to the court and tell the court what's going on. So some parents think they can get away with it and be secretive of it, but oftentimes it comes out and it bites that parent. So don't do that. Don't disparage the other parent, and don't share anything about the case with any of the children, no matter how old they are, whether they're 16 or 17. If they're minors, they're under the age of 18, or they're still subject to the jurisdiction of the court, don't share anything about the legal proceedings with the children pursuant to this provision of the statute. So, item number 19, the developmental stage and needs of the child and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. So this is interesting. Developmental needs, obviously younger children have different developmental needs than older children. In Florida, we used to have something called the doctrine of tender years. That was done away with back in the 70s. It used to say that children of tender years, young children, should be with their mother. Obviously, with women's lib and gender-neutral provisions in the statute, is no longer effective. So this is an interesting provision in the statute that, taking into consideration the developmental needs, it doesn't mean that one gender can necessarily provide better parenting for younger children versus older children. This is a very subjective factor. I think as long as it doesn't matter if you're mom or dad, if you're involved in, for even young children, changing diapers, earlier bedtimes, providing appropriate food and so forth for younger children versus older children, considering their developmental needs, being involved in their extracurricular activities. This is kind of related to the prior, one of the prior factors, but I think this is a very difficult factor for the court to really apply, but because it's not a gender specific provision. Okay, all right. So finally, the last factor is any other factor that is relevant to the determination of the specific parenting plan, including the time-sharing schedule. So any other factor, you as the client are going to know the facts of the case better than anyone else. You know your children, you know how they may have special needs, medically, emotionally, educationally, or otherwise. So you need to let your attorney know those. If there's something different or unique about your child that the court needs to take into consideration, let your attorney know so you can prepare that as part of the case. We haven't really talked about religion here. It's not really in the factors, but if there's some specific involvement of your child in religious training or in the church or in a youth group or something like that, then let your attorney know that. Typically what I see with those is the court says, well, the parent who has the children during their time sharing can have the children involved in religious training or take them to church. If there's a certain series of training events that will happen across the board during both parents' time sharing with the minor child or children, then the court can order that the child be taken to all of those training or classes or whatever. So those are the kinds of any other relevant factors. So anything that's relevant, let your attorney know. So I hope this has been helpful. If it has, would love it if you would subscribe to the channel, at least hit the like button so others can know that this is valuable content. If you have any questions or comments, please put those in the comment section below. For a healthy living tip, I have been talking at the last 3 videos about getting a good night's sleep, maintaining healthy rest. We talked about lighting. We talked about making it quiet, cooler, all those kinds of things. The last thing I would say is try to avoid excessive alcohol, especially in the evenings, because that can really affect your ability to get a good night's sleep. So alcohol, of course, in moderation. I want my clients always to be healthy, to be alert, to be a part of the team. You are, the facts, as I've said. So you're the fact person, the fact part of the team. We know the law, we provide the law, we put the facts and the law together and make it very effective. So thank you for watching this 4-part series. And as always, we're going to be posting our next videos on Wednesdays each week. So look for our next video. We look forward to seeing you again soon. Thanks.